Thank you, Cathaoirleach. It's good to be back and delighted to be here specifically dealing with this piece of legislation, and I just want to thank Senators for attending this evening's debate. I'm really pleased to present this bill and for the opportunity to discuss it with members of the Seanad. Obviously this has gone through the Dáil, so it's important that we have an opportunity to discuss and debate here. Enactment of this bill will deliver two important programmes for government commitments. One, to introduce hate crime legislation for the very first time in order to ensure that those who target victims because of their association with a particular characteristic, that they are identified as perpetrators of hate crime. The second is to repeal and update the Prohibition of Incitement to Hatred Act of 1989 so that those who seek to encourage and incite hatred against a minority and vulnerable groups, that they can be prosecuted. Enactment will also ensure full transposition of an EU framework decision on combating certain forms and expressions of racism and xenophobia by means of criminal law. The Ireland that we inhabit today is a diverse country. It is increasingly open, it is welcome, and I believe it is progressive. However, as with every society, there is a very small minority of people who target the most vulnerable amongst us purely because of a hatred of some inherent part of their identity. And I know that every member of this House recognises that hate speech and hate crime can cause untold trauma for victims, their communities and their broader society. In fact, research shows that victims of hate crime suffer significantly more distress than victims of other crimes. Such crimes are completely reprehensible, they're unacceptable, yet hate-based offences have become increasingly common in recent years. It often feels like we take 2 steps forward and 1 step back. And Garda Síochána reported a 29% increase in reported hate crimes in 2022 compared to the previous year. The most prevalent discriminatory motives for hate crimes last year were race, sexual orientation and nationality. We all know June is Pride Month. I had the pleasure of speaking at the launch of Navan Pride last night, and this comes just after an appalling attack against a young member of the LGBTQ+ community in Navan, in my own county. And what was very clear last night is that the community have come together to very clearly say that members of the LGBTQ+ community, that you should be entitled to live in a safe way in your own community and to love who you want to love. And it was a very clear message last night. Last year saw similar horrendous acts in Sligo, in Dublin and in Cork, targeting of immigrants, people with disabilities, members of the traveller community, simply because of who they are. It's shocking, but unfortunately it is tragically frequent. It's hard to believe that despite increased instances of hate crime and general support from the public to criminalise such acts, Ireland doesn't actually have hate crime in place. We will be one of the last countries in Europe to enact such legislation. That's why it's so important that we enact this bill. And while we have legislation in place against hate speech, which has been there for almost 35 years, it has been ineffective, it's limited and it has been largely discredited. We bear a responsibility as legislators to do our utmost to provide a safe, fair and inclusive country for all, reflecting the modern Ireland that I spoke of earlier. The overwhelmingly positive passage of this bill through the Dáil has made me very optimistic that the legislation is victim-centred, timely, it's clear in its protections and provisions for those most seriously affected by hate crime and hate speech. The bill, I think, has been broadly welcomed across the political spectrum, as well as by the large and diverse array of representative organisations of these minority groups that we are seeking to protect. And while there has been much valuable and I think very positive discussion and reflection since the government announced its intention to legislate in this area, it has unfortunately been subject to deliberate misinformation and distortion, including from fringe commentators and US-based social media personalities, of whom I don't need to mention. In framing our discussion in this House, I hope you will keep in mind that the core purpose of delivering this legislation is to ensure that vulnerable and minority communities can feel safe. That is the core aim of what we are setting out to achieve here, that we keep people safe. Nobody deserves to be targeted for the intrinsic and unchangeable characteristics of their identity. To do so, it's cowardly, it's callous, it's contemptuous, and it should be open to prosecution. The increase in hate crime is not limited to Ireland, but rather this is something of more broader phenomenon globally. It's often fuelled and indeed amplified by social media and politicisation of certain media outlets that really do attempt to use so-called culture wars to reach a wider audience. The approach we have taken in developing this bill has been to develop a very much evidence-based, fit-for-purpose and legally prudent approach to legislating for hate-based offences in Ireland, one that's in line with EU and international good practice. Development of this legislation is underpinned by an extensive public consultation and research process that began in 2019, so any suggestion that this is rushed, it has been anything but. This included a short public survey, detailed written submissions, 7 independently facilitated discussion workshops around the country, a series of meetings with stakeholder groups, civil society, academics, law enforcement professionals and other experts. First-hand testimony and lived experiences that emerged from the facilitated workshops and meetings with the various different victims groups was, I think, particularly insightful for any of us who read through what was discussed. It was profound and in many instances devastating. There's literally people in this country who do not leave their house because they are afraid. It provided much needed awareness raising of the true hostility that these people face by vulnerable and minority communities across Ireland. I have no qualms in standing up against those who would criticise this bill, who say that hate speech and hate crime don't exist in this country. That's simply not true. Most of these proclaiming the loudest don't seem to have taken the time to actually read this bill, to understand that it doesn't seek to infringe on their rights to say offensive things, nor do they seem to understand that hate speech is already a crime in Ireland. This legislation was developed with the objective of providing that the individuals who target victims because of their association with a particular identity characteristic, that they can be identified and they can be prosecuted. This is a requirement of the EU framework decision that we must transpose. There has been some recent discussion, and I might touch maybe on some of the issues that have been raised and discussed in these houses, but in public as well. Terminology used in the legislation throughout its development, particular attention has been given to the persons or the group of persons designated under the protected characteristics as set out in section 3 of the bill. These are race, colour, nationality, religion, national or ethnic origin, descent, gender, sex characteristics, sexual orientation and disability. These protected characteristics, which underpin the legislation, were selected on the basis of the public consultation and the submissions from key stakeholders. They are characteristics most commonly targeted for hate-based offences in our country. The meaning given to these protected characteristics in the bill are for the specific purpose of this legislation. We're not seeking to change existing statutory definitions, as some have claimed. This is specific to this legislation. Indeed, it's very common in legislation to have different meanings and different terms in different acts depending on the specific purpose of the legislation in question. The meaning of gender as a protected characteristic in the bill expressly provides for gender expression or identity in order to include transgender and non-binary persons. This is in line with the international good practice and was a strong recommendation from stakeholders. Similarly, the addition of sex characteristics and descent as protected characteristics was to ensure that the bill is as inclusive as possible, to include intersex persons and to include people of Jewish descent or mixed race, again further to recommendations from minority communities. During the Dáil debates, there was also some discussion around defining hatred in the bill. On the strong advice of the Office of the Attorney General, so the former Attorney General, at the beginning of this government and the current Attorney General, we have not sought to limit the definition of what is a widely understood concept of hatred beyond its ordinary and everyday meaning. It is the definition which has been used by the courts, by the Gardaí, by the DPP, and I'm advised that defining it further at this juncture could risk prosecutions collapsing and victims being denied justice. Furthermore, it has been an established term on the statute books for several decades, as this is a definition we're carrying on from the 1989 Act. If we're to use different words, we simply have to try and describe what those different words mean. It makes absolutely no sense. That Act, which will be repealed, the 1989 Act, and replaced by this bill, has been on the statute book for nearly 35 years. It has resulted in 50 convictions in this period, and many of these were successfully appealed. In updating our incitement or hate speech laws, we have to recognise that there are individuals and groups that are deliberately and recklessly spreading hatred in our country without any regard for the people that they are victimising. However, I need to make this clear. No one has a right not to be offended. We're not saying that we're going to legalise or criminalise somebody offending another person. That's not what's happening here. The right to freedom of expression and freedom of speech are vital rights in any democratic society, and I will defend them the same as anybody else. These rights are protected by the Irish Constitution and the European Convention of Human Rights. You have a right to express your convictions, your opinions, no matter how unpopular they might be. You have a right to be divisive, you have a right to be argumentative, as we all are in here many times, a right to offend others, and to hold political opinions which are not the mainstream. Section 11 of the bill explicitly provides protection for freedom of expression. This section provides that discussion or criticism of matters relating to a protected characteristic does not constitute incitement to hatred in and of itself. However, freedom of speech is not an absolute right. We've seen in other countries where words can result in violence, can result in incitement to hatred. You don't have to shout fire, or you don't have a right to shout fire in a crowded room. You don't have a right to make defamatory statements, and you don't have a right to incite hatred or violence against individuals. When a communication incites hatred or violence against others, a very clear line is crossed, and such behaviour must be dealt with through effective and prosecutable legal recourse. The incitement offences that currently exist under the 89 Act are being updated to encompass any communication or behaviour that intentionally or recklessly incites hatred or violence, so that they can be prosecuted more effectively. This is not about lowering any bar, this is about updating legislation that already exists. The key change here is that we are simplifying the core incitement offence and setting the standard at recklessly or intentionally inciting hatred. Recklessness is a very common feature in criminal law already. This means a person must have either deliberately set out to incite hatred or violence, or they knew that what they were doing would incite hatred or violence, and they did it anyway. So this is the change that's happening. This is already on the statute books, but we are now including essentially recklessness as part of that. While still very challenging to prove, including recklessness as part of this offence, it was widely welcomed during the pre-legislative scrutiny process. It's hoped that this will contribute to more effective implementation of this legislation in comparison with the existing Act. It is a lesser offence to prepare or possess material such as posters or leaflets which is intended or is likely to incite violence or hatred, even if the material has not yet been shared or made public. However, there would have to be evidence that the person intended, and that is the material that would be made public, in order to secure a conviction. This provision, I think, has attracted a lot of attention with claims that it equates to from hate speech to thought crime. However, these provisions in relation to possessing material is exactly a replica of what is in the 89 Act that we are talking about. So what we're talking about here is not new. I wish to make it clear that this only applies in cases where an individual has a very clear intention to disseminate harmful material that would stir up violence or hatred, and this would need to be proven in court beyond a reasonable doubt. It's been carried over from the 89 Act, as I've said, it's not new, and it's to cover situations where material might be intercepted before it's communicated. So, for example, in a case of a person travelling to a rally, to a far-right rally, perhaps with posters expressly inciting hatred or violence, and it's in their car or it's found in their backpack. Now, we have this already, and we don't have a huge amount of cases that have been brought. A lot of this is now online, so we need to make sure that we update our legislation that includes online communication. But again, there has to be clear evidence of intent or likelihood to stir up violence or hatred for a prosecution to be brought in this section. In terms of the burden of proof, again, something that has been discussed a lot, the burden of proof for preparing and possessing material likely to incite violence or hatred is consistent with what is already on the statute book of the 89 Act. Again, we're not changing things, this is already in law. What I'm proposing is to maintain this standard, as to do otherwise would make convictions significantly more difficult to secure, even where these offences have clearly taken place. Reverse burdens of proof, as applied here, are a common feature of criminal legislation. So, for example, Section 15.2 of the Misuse of Drugs Act 1977, a person in possession of a large quantity of a controlled drug is presumed, until the court is satisfied to the contrary, to possess these drugs for the purposes of sale or supply to a third party. This doesn't affect the protections that we have built into our laws around the presumption of innocence, and the general burden of proof remains on the prosecution to show the facts of the case to the court. This is no different. I reiterate that all of the incitement provisions have been carefully drafted to criminalise only the extreme forms of hate speech that deliberately and recklessly incite or stir up acts of hostility, discrimination or violence. The legislation contains robust safeguards for freedom of expression, such as protections for reasonable and genuine contribution to literary, artistic, political, scientific or academic discourse, and fair and accurate reporting. This is about criminalising those who deliberately or knowingly put other people in harm's way through their statements and through their views. Fundamentally, free speech does not entitle any person or group to cause harm to another. Similarly, we have a responsibility to tell victims of hate crimes that we are determined to keep them safe from harm and to let perpetrators know that they will be punished for spreading hatred. As I mentioned, hate crime causes significant psychological trauma and distress to victims, and we have to offer the most vulnerable communities within our society the protections that they need, and indeed to give An Garda Síochána and the DPP the powers necessary to investigate and prosecute these crimes for what they actually are. A hate crime happens when someone commits an offence because they have a hatred of a person with a particular personal characteristic. For example, if someone was followed leaving an LGBTQ+ bar, they were assaulted but also shouted at using homophobic slurs, they have, under this, been subject to hate crime. Another example would be if someone's property is intentionally damaged where anti-immigrant or anti-migrant slogans were painted on their property because they were a member of the migrant community. So it is that demonstration test. Assaulting someone or damaging their property, it's already a crime. It is hatred against an individual or group on the part of the perpetrator that makes it a hate crime. If I could, because there's just a lot to cover, and I think I'll be able to address a lot of what's coming up, if that's
agreement from the House.
Is that okay? For the purpose of the bill, now that I have the time. For the purposes of this bill, there are 12 aggravated offences which can be classified as hate crimes. These vary from very serious offences like assault to violent public order offences or criminal damage. These offences have been selected as they are again the most commonly cited crimes against people on identity grounds. Where a perpetrator is found guilty of one of these offences that is aggravated by hatred, a sentence uplift will be applied in comparison to the base offence. This will be a matter again for the trial judge to determine the appropriate sentence. However, a maximum additional sentence of +6 months for a summary conviction and +2 years for conviction on indictment will be available, except where already at the maximum possible. We have built in a safeguard so that where there isn't sufficient evidence to convict a person of the hate crime offence, they may still be convicted of the base form of the offence. So if someone is assaulted and it's a hate crime, whether they succeed in the hate crime side of it, it's still an offence because they've still been assaulted. This avoids the risk that the entire prosecution could fall if the hate element can't be proven. So if a person is assaulted and it isn't a hate crime, there can still be a conviction for assault. Also included is a general provision under Section 20 of the bill, which provides that where there is evidence of hatred in relation to any offence beyond the 12 specific aggravated offences, hatred can be considered as an aggravating factor at sentencing, and the judge will be able to reflect this in the offender's record. This formalises a process that is already a judicial reality in our court system and offers the broadest protection possible for victims of offences that are aggravated by hatred. The proposed test of proof in hate crime cases would be evidence of motivation by hatred against someone with a protected characteristic and or a test of demonstration of hatred against someone with a protected characteristic around the time of committing the offence. The addition of this latter demonstration test stems from the pre-legislative scrutiny conducted by the Oireachtas Committee, the Justice Oireachtas Committee. The committee strongly recommended that the bill include a demonstration test in addition to the existing motivation test in this bill. This recommendation emerges on the basis of the considerable challenges in actually proving motivation in hate crimes. Motivation is not required to be proven in most other crimes. Rather, the normal legal standard in most crimes is proof that you've actually just committed the crime. The demonstration test allows for this normal standard of proof to be applied in the course of seeking a prosecution for a hate crime. In the most basic sense, a demonstration test means that a perpetrator demonstrated hatred towards someone with a protected characteristic at the time of the offence being committed. So again, as I've mentioned, through a particular slur, graffiti, or in some other way. This is an objective test, so that is, what would a reasonable person believe? It's not the accused's own belief. Inclusion of the demonstration test was an express recommendation of the Justice Committee in order to ensure that Ireland's new hate crime legislation is effective. Legal experts have noted that without this legal test, there is little point in putting the hate crime into statute. The Government approved my recommendation to include the demonstration test in the text of the bill last July. This decision again came on foot, as I've said, of the Justice Committee's recommendation, and we have looked at other jurisdictions. We have obviously examined this recommendation and decided that this is the route that is necessary to ensure that we can ensure convictions. Contrary to concerns that the demonstration test would lead to a spike in convictions, including for spurious claims, evidence from these other jurisdictions show that the conviction rate for hate crimes and the guilty plea for hate crimes is at a similar level to that of normal crimes. In Northern Ireland, for example, where a demonstration test of proof has been in effect for For many years, the Public Prosecution Service receives 344 files involving hate crime in 2021-22. Over the same period, over 4,500 hate crimes and hate-motivated incidents were reported to the PSNI. So I think this highlights that there isn't a deluge of hate crime convictions just because the demonstration test exists. Importantly, it centres on the effect the hate crime has on the victim rather than having to prove the hateful intent and the motivation of the offender. It is, after all, the demonstration of hate that actually causes the harm to the individual. So I mentioned earlier that proof shows victims of hate crime are more seriously impacted. It's not necessarily the assault or the act itself, it's the demonstration of hate towards that person that causes the most amount of harm. I'm aware that this was discussed in the final debate in the Dáil. An example was given about someone making a slur in the heat of the moment, which could lead to them having a hate crime on their record, and that this perhaps could be disproportionate. I think we need to be clear, there's absolutely nothing disproportionate in how someone feels when being assaulted or otherwise offended against because of hatred for who they are. There's absolutely nothing disproportionate about that, and we need to be clear about that. There is a profound difference between how victims of hate crimes feel in comparison to victims of other crimes. We must remember this at all stages of this debate. It's also important to say that a prosecution cannot be brought forward without the direction of the Director of Public Prosecution, and this is an important safeguard that is in place. To conclude, and my apologies for taking longer, but I do think there's a lot, and it's an important bill that we need to be able to discuss at length. I'm looking forward to engaging with all of my colleagues today, and I'm sure in the course of the next few weeks. I recognise that there are different viewpoints, with some saying the bill doesn't go far enough. There are some who say it goes way too far, but I can assure you that this bill is not radical, as some would claim. It is proportionate. It is very much evidence-based. It's in line with legislation in other countries similar to ours, and I hope that I can count on your support to progress this much-needed legislation that has been resoundingly welcomed by those who live in this country and who have been impacted by hate speech and by hate crimes. Thank you.